This is part 53 as far as our lecture series is concerned. And in this part, we start dealing with chapter 21, capital A, dealing with plea bargaining. In order to understand this, we have to start right from section 265A up to section 265L to understand the same. And then as we start with section 265A, which deals with application of the chapter, and it says this chapter shall apply in the respect of an accused against whom, small a, the report has been forwarded by the officer in charge of the police station under section 173, alleging therein that an offence appears to have been committed by him other than an offence for which the punishment of death or of imprisonment for life or of imprisonment for a term exceeding 7 years has been provided under the law for the timing in force, or small b, a magistrate has taken cognizance of an offence on a complaint other than an offence for which the punishment of death or of imprisonment for life or of imprisonment for a term exceeding 7 years has been provided under the law for the timing in force, and after examining the complainant and the witnesses under section 200, issued the process under section 204, but does not apply where such offence affects the socio-economic condition of the country or has been committed against a woman or a child below the age of 14 years. Subclause 2 says, for the purposes of subsection 1, the central government may, by notification, determine the offences under the law for the timing in force, which shall be the offences affecting the socio-economic condition of the country. And then if you go through the notification, as far as the government is concerned, it says, in the exercise of the powers conferred under subsection 2 of section 265 capital A of the Code of Criminal Procedure, the central government hereby determine the offences under the following laws for the timing in force, which shall be the offences affecting the socio-economic condition of the country for the purpose of subsection 1 of section 265 capital A of the said Act, namely Dowry Prohibition Act of 1961, the Commission of Sati Prevention Act of 1987, the Indecent Representation of Women Prohibition Act of 1986, the Immoral Traffic Prevention Act of 1956, Protection of Women from Domestic Violence Act of 2005, the Infant Milk Substitutes Feeding Bottles and Infant Foods Regulation of Production, Supply and Distribution Act of 1992, Provisions of Fruit Products Order 1955 issued under the Essential Services Commodities Act of 1955, Provisions of Meat Food Products Orders 1973 issued under the Essential Commodities Act of 1955, offences with respect to animals that find place in Schedule 1 and Part 2 of Schedule 2, as well as offences related to altering of boundaries of protected areas under Wildlife Protection Act of 1972, the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act of 1989, offences mentioned in the Protection of Civil Rights Act 1955, offences listed in section 23 to section 28 of the Juvenile Justice Care and Protection of Children Act of 2000, the Army Act of 1980, the Air Force Act of 1950, the Navy Act of 1957, offences specified in sections 59 to 81 and 83 of the Delhi Metro Railway Operation and Maintenance, the
Explosives Act 1884, offences specified in section
11 to 18 of the Cable Television Networks Regulation Act of 1995 and Cinematograph Act 1952. So this is application of the chapter as far as plea bargaining concerned, which is dealt as far as section 265 capital A of the Criminal Procedure Code is concerned. Now section 265B tells you the procedure, namely application for plea bargaining, and it says a person accused of an offence may file an application for plea bargaining in the court in which such offence is pending for trial. Subclause 2 says the application under subsection 1 shall contain a brief description of the case relating to which the application is filed, including the offence to which the case relates, and shall be accompanied by an affidavit sworn by accused stating therein that he has voluntarily preferred, after understanding the nature and extent of punishment provided under the law for the offence, the plea bargaining in his case, and that he has not previously been convicted by a court in a case in which he had been charged with the same offence. Subclause 3 says, after receiving the application under subsection 1, the court shall issue notice to the public prosecutor or the complainant of the case as the case may be, and to the accused to appear on the date fixed for the case. Subclause 4 says, when the public prosecutor or the complainant of the case as the case may be, and the accused appears on the date fixed under subsection 3, the court shall examine the accused in camera, where the other party in the case shall not be present, to satisfy itself that the accused has filed the application voluntarily, and where, subclause A says, the court is satisfied that the application has been filed by the accused voluntarily, it shall provide time to the public prosecutor or the complainant of the case as the case may be, and the accused to work out a mutually satisfactory disposition of the case, which may include giving to the victim by the accused the compensation and other expenses during the case, and thereafter fix the date for further hearing of the case. Small b says, the court finds that the application has been filed involuntarily by the accused, or he has previously been convicted by a court in a case in which he had been charged with the same offence, it shall proceed further in accordance with the provisions of this code for the stage such application has been filed under subsection 1. Section 256 capital C says guidelines for mutually satisfactory disposition, and it says in working out mutually satisfactory disposition under subclause A of subsection 4 of section 265B, the court shall follow the following procedure, namely, small a, in a case instituted on a police report, the court shall issue notice to the public prosecutor, the police officer who has investigated the case, the accused and the victim of the case to participate in the meeting to work out a satisfactory disposition of the case, provided that throughout such process of working out a satisfactory disposition of the case, it shall be the duty of the court to ensure that the entire process is completed voluntarily by the parties participating in the meeting, provided further that the accused may, if he so desires, participate in such meeting which with his pleader, if any, engage in the case. Small b says, in a case instituted otherwise than on a police report, the court shall issue notice to the accused and the victim of the case to participate in meeting to work out a satisfactory disposition of the case, provided that it shall be the duty of the court to ensure throughout such process of working out satisfactory disposition of the case that it is completed voluntarily by the parties participating in the meeting, provided further that if the victim of the case or the accused, as the case may be, so desires, he may participate in such meeting with his pleader engaged in the case. Now, section 265 capital D deals with a report of the mutually satisfactory disposition to be submitted before the court, and it says where in a meeting under section 265 capital C, a satisfactory disposition of the case has been worked out, the court shall prepare a report of such a disposition, which shall be signed by the presiding officer of the court and all other persons who participated in the meeting, and if no such a disposition has been worked out, the court shall record such observation and proceed further in accordance with the provisions of this code from the stage the application under subsection 1 of section 265B has been filed in such a case. Now, how section 265E capital E deals with disposal of the case, and it says where a satisfactory disposition of the case has been worked out under section 265 capital D, the court shall dispose of the case in the following manner, namely: small a, the court shall award the compensation to the victim in accordance with the disposition under section 265 capital D, and here the parties on the quantum of punishment, releasing of the accused on a probation of good conduct or after admonition under section 360, or for dealing with the accused under the provisions of the Probation of Offenders Act of 1958 or any other law for the timing in force, and follow the procedure specified in the succeeding clauses for imposing the punishment on the accused. B. After hearing the parties under clause A, small a, if the court is of the view that section 360 or the provisions of the Provision of Offenders Act of 1958 or any other law for the timing in force are attracted in the case of the accused, it may release the accused on probation or provide the benefit of any such law as the case may be. Subclause C. After hearing the parties under clause small b, if the court finds the minimum punishment has been provided under the law for the offence committed by the accused, it may sentence the accused to half of such minimum punishment. Small d. In a case after hearing the parties under clause small b, the court finds that the offence committed by the accused is not covered under clause small b or clause small c, then it may sentence the accused to 1/4 of the punishment provided or extendable as the case may be for such offence. Section 265F deals with judgment of the court, and it says the court shall deliver its judgment in terms of section 265A in the open court, and the same shall be signed by the presiding officer of the court. Section 265G deals with finality of the judgment, and it says the judgment delivered by the court under section 265G shall be final and no appeal except the special leave petition under Article 136 and writ petition under Article 226 and 227 of the Constitution shall lie in any court against such judgment. Section 265 capital H deals with power of court in plea bargaining, and it says a court shall have, for the purposes of discharging its functions under this chapter, all the powers vested in respect of a bail, trial of offences and other matters relating to the disposal of the case in such court under this code. Section 265I deals with period of detention undergone by the accused to be set off against the sentence of imprisonment, and it says the provisions of section 428 shall apply for setting off the period of detention undergone by the accused against the sentence of imprisonment imposed under this chapter in the same manner as they apply in respect of the imprisonment under the provisions of this code. Section 265 capital J deals, which is the saving clause, says the provisions of this chapter shall have the effect, notwithstanding anything inconsistent therewith contained in any other provision of this code, and nothing in such other provisions shall be construed to constrain the meaning of the provisions of this chapter. And the explanation says, for the purposes of this chapter, the expression public prosecutor has the meaning assigned to it under clause U of section 2 and includes an assistant public prosecutor appointed under section 25. Section 265K, statements of accused not to be used, and said, notwithstanding anything contained in any law for the timing in force, the statement or facts stated by an accused in an application for plea bargaining filed under section 265 capital B shall not be used for any other purpose except for the purpose of this chapter. And the last part, namely section 265 capital L, deals with non-application of the chapter, and it says, nothing in this chapter shall apply to any juvenile or child as defined in clause small k of section 2 of the Juvenile Justice Care and Protection of Children Act of 2000. So this is as far as plea bargaining is concerned, where we have to take into consideration right from section 265 capital A up to section 265 capital L of the Criminal Procedure Code. With this, now there are some maybe sections or a number of sections with which we shall be dealing for the purpose of proceeding further, and hence in the next lecture the first section with which we shall be dealing is section 300 of the Criminal Procedure Code, which is based on the maxim atrofis convictor atrofis acquit. As soon as we finish with that section, we shall be dealing right from section 306 up to section 308 of the Criminal Procedure Code, which deals with tender of pardon. And then during course of time, if it is necessary, we shall be dealing with some more sections of the chapter as and when required.